Madam President, I thank you most sincerely for the opportunity to contribute to this debate. You know, in my usual form and fashion, Madam President, I would always pelt a few blows at Senator Mark before I jump into the crux of my contribution. There are certain things that Senator Mark, of course, would have made, certain points he would have made, which, of course, I would attempt to address. But this debate, Madam President, is actually a very, very critical debate. And it's a debate which really warrants careful consideration because it stands to critically impact on the government's ability to deal with crime and criminality in this country. And I'm saying this because, Madam President, my intention, at least during my contribution in this debate, is to attempt to convince all senators who are sitting here to give us that support that we require in order to breathe life, a continued life, into the amendment and into the bill that we have presently before the Senate. Now, you know, I recall in a previous debate I mentioned that the Parliament is often regarded as the highest court of the land, and it is something that I truly believe. And in a previous debate I also indicated that if this is the highest court of the land, it means that I'm speaking to you, the members of the jury. That's the honourable senators who sit in this Senate. I'm also speaking to the people of Trinidad and Tobago, asking for that support that we require in order to make Trinidad and Tobago a safer place for us all. And it is my hope, Madam President, that throughout my contribution, I may add to what the Attorney General has already stated and make further contributions in trying and attempting to respectfully convince this Senate why your vote in support of this bill is critical and why we are here asking for your support, because we recognize as a government that this bill is critical, as I stated before, in bringing changes or in assisting us in our crime fighting efforts. Now, Madam President, Senator Mark made the statement that this amendment is executive imprisonment. Well, respectfully, Madam President, I will say to the Senator, instead of running out of the chamber like a little schoolboy when the Attorney General was on his legs, respectfully, Madam President, had the Honourable Senator remained in this chamber during the Attorney General's contribution, he would have heard the Attorney General make reference to a Mauritius case, the case of the state versus Karate. Now, Madam President, at page 8 of that particular case, the Attorney General, Lord Stein in that case stated, the exercise of granting bail is a judicial one. It is a judicial act in the same way as passing sentence and must be left to the judiciary. So the Attorney General did acknowledge what is the role and function of a judicial officer in the granting of bail. This is not new information to us as parliamentarians. We understand what bail and we understand the role that the judicial officer plays in the grant of bail. But, Madam President, what we need to remember is that we are not taking away a right, I respectfully submit. What we are doing, Madam President, is deferring that right with an imposition, Madam President, of 120 days timeline. Now, Senator Mark also proceeded in his contribution, Madam President, to make statements about the Attorney General, highlighting the AG's change in position when he served as the head of the Law Association and now in his capacity as the Attorney General. Again, Madam President, respectfully, had Senator Mark remain in this chamber and do the people's work instead of running out of the chamber when the Attorney General was on his legs, Senator Mark would have heard the Attorney General read into the record why his position from 2016 to now have changed. And if I may respectfully read, Madam President, from a statement made by the Attorney General when he was the President of the Law Association, at paragraph 4 of that statement, the Attorney General said the significant deficiencies of forensic system resulting in unreasonable delay in forensic testing means that persons are unlikely to have matters involving the use of firearms heard at a minimum of 2 or 3 years. At paragraph 5 5 of that said letter, the Attorney General said there are no safeguards against malfeasance by police officers in situation in which the mere mention by a police complainant of suspicion of possession of a firearm, open brackets, or something resembling a firearm, invokes the no bail provision. Now, what the Attorney General, so this is what the Attorney General's position was in 2016. But we have heard the Honourable Attorney General explain to this country, explain to this Honourable Senate, the reason for his position considerably changing is because from 2016 to 2022, we have had significant improvements and changes in our criminal justice system. So to say that the Attorney General is somewhat changing his position is correct. He has changed his position as it relates to the support of this bill. But the reason being, the Honourable Attorney General would have indicated clearly that is because certainly circumstances from 2016 to 2022 has considerably changed. And as a consequence of that, he is confident that this bill stands to bring about certain changes that will positively impact on our criminal justice system. Now, Madam President, Senator Mark then proceeded, right. If I may go on to a question that was asked by Senator Mark and Senator Richards relative to statistics on crime and, of course, the impact, a question relative to the impact on or whether or not this amendment has brought any impact at all in crime and criminal activity. Madam President, I want to respectfully submit and remind honourable senators that the extension that we seek today covers offences that are stated in Part 2 of the first schedule of the Bail Act. There are a list of offences, Madam President, a list of criminal offences in which a person can be denied bail for 120 days. Murder is but one of those offences. You know, Madam President, respectfully, I often hear people persons in the public, you know, we speak about crime, and of course, there is an upsurge of crime in our country. But what we need to remember is that murder alone is not the only criminal offense that exists. And when we are trying to assess whether or not this bill and this extension is assisting in crime detection, we have to remember that we are not applying this tort to the offense of murder alone, because there are other Part 2 offenses, well, Part 2 of the first schedule in the Bail Act. There are a list of other offences which this amendment will apply to. Now, for the benefit of course, the Honourable Senate and for, of course, the country, I received some important data, Madam President, from the Crime and Problem Analysis Branch of the Trinidad and Tobago Police Service. And what this statistics does, Madam President, it actually breaks up and it delves into some of the offences that Part 2 of the first schedule of the Bail Act covers. And what I want to read into the record, Madam President, I will start with the most common offense, which we often judge criminality in our country by, which is murder, right? Now, in 2019, Madam President, based on the statistics that I have before me, as it relates to the offense of murder, we have had the TTPS reports that there were 539 reported cases of murder in 2019. What we have is an 85 of those cases, we have it being detected, or what the TTPS refers to as detection. Now, detection pursuant to this statistics, Madam President, the TTPS detection is referred to as the solved cases which are reported to the TTPS. So the stats that I'm going to respectfully read into the record, Madam President, would range from 2019 to 2021. In these stats, the TTPS focuses on reported cases and then they go on to speak to detected cases. For the members of the listening public and for members of the Senate, the detected cases are those solved cases which were reported to the TTPS. Now, I will admit that when we look at the statistics, of course, it leaves a lot to be desired. And of course, we would wish if we can have a higher detection rate of crime in our country. But the reason why I believe it's critical for me to make reference to these statistics, Madam President, is because what we can see is that there has been an assistance, and as it relates to the amendment that we seek here in dealing with these criminal activities. So as I would have started looking at murder, in 2020, Madam President, there were 339 cases reported. We had a detection rate of 81 cases. In 2021, the TTPS reports 450 murders. Detection, we have 72 cases. If I go to another, so murder, as I said before, is but one of the offences that exists in Part 2 of the first schedule of the Bail Act, in which this bail restriction will apply to. Let's look at another offence that sometimes we take for granted. Let's look at receiving stolen goods. Receiving stolen goods, Madam President, is an offence that falls under Part 2 of the first schedule of the Bail Act. If we look at 2019, what we have had is 50 TTPS reports, 15 reported cases. When they turn to detection, we have 15 of those cases detected. And to remind you all, detected means solved cases which were reported to the TTPS. Now, from 2019, this was when the amendment would have come into being, where we looked at the 120-day bail restriction. Now, if we look in looking at the offence of receiving stolen goods, in 2020, the TTPS reports there were 13 reported cases of receiving stolen goods. We have a detection of 13 cases. If we look at 2021, we have under the receiving of stolen goods, we have reported 25 cases. We have a detection of 25 cases. So, and that is another offense, Madam President, which this amendment will apply to. If I go to, for example, wounding and shootings, Madam President, with respect to wounding and shooting, it comes under, again, Part 2 of the first schedule of the Bail Act, which this 120 days restriction applies to. In 2019, Madam President, there were 686 reported cases of wounding and shootings. How many detected cases? We had, again, detection, meaning solved cases, which were reported to the TTPS, 226. Now, of course, we are not where we want to be. The TTPS is not where it wants to be. But certainly we have been making, well, not we, but the TTPS have been making inroads in dealing with some of these offences. When we look at wounding and shooting in 2020, Madam President, we have 525 reported cases. Out of that 525 reported cases, the TTPS reports that 189 are detected cases. When we look at 2021, Madam President, under wounding and shooting, we have 675 reported cases. Out of those 675 reported cases, Madam President, we have 217 detected as solved cases, which were reported to the TTPS. Madam President, if I go now to another offense, sexual penetration of a child, that is in E Part 2 of the first schedule, again, an offense which this 120-day bail restriction relates to. If we look at in 2019, Madam President, there were 370 reported cases of sexual penetration of a child. The TTPS reports that there are 84 of those cases. We are looking at detected cases, again, detection meaning solved cases which were reported. In 2020, Madam President, as it relates to the offense of sexual penetration of a child, we have 379 reported cases, 146 in that year being detected. If we turn to the same offense, sexual penetration of a child in 2021, we are looking at 649 cases that were reported, 159 cases that were detected. If I go to, and Madam President, I know it seems redundant by going through this, but I believe this data is critical critical in at least being able to show the members of this Honourable Senate that based on the statistics that we have, of course, there still leaves a lot to be desired. Of course, we wish if every single matter that is reported to the TTPS, that we can certainly have that matter being detected according to the TTPS, solve cases which are reported to them. Of course, we wish as a country, as a nation, just as a regular citizen of Trinidad and Tobago, it is our desire that every single matter that is reported can be detected, right? So, of course, we are not exactly where we want to be. But we have to recognize, Madam President, that this bill, this amendment, I want to reiterate, it does not cover the offense of murder alone. There are several offenses in which this 120-day bail restriction will apply to. And based on the information that I have from the Crime and Problem Analysis branch of the TTPS, what we can see is that we have reported cases from the period of 2019 to 2021. And based on the detection rate, we have made inroads in detecting some of these offenses, which in my respectful submission, Madam President, should of course sway the members of this Honourable Senate in at least giving us the support we require, recognizing that this restriction has made some inroads in the detection of crime. Madam President, if I look at the offense of buggery, for example, which is a serious offense under the Part 2 of the first schedule of the Bail Act. In 2019, Madam President, there were 16 reported cases of buggery. 9 out of, again, it's not perfect, but we have 9 out of 16 cases, Madam President, which were detected. In 2020, we had 9 cases of buggery reported. 5 out of 9, Madam President, were detected. In 2021, which I'm particularly pleased with, there were 9 cases of buggery reported, Madam President. 9 detected. Again, detection meaning solved cases which were reported to the TTPS. So that is another offense. That is another offense, Madam President, in which this amendment, of course, will apply to. Madam President, if we look at, for example, narcotic offenses, we're always talking about drugs. Narcotic offenses in 2019, this statistic states that there were 417 reported cases. Madam President, in 2019, 417 of those cases were detected. Detected meaning solved cases which were reported to the TTPS. In 2020, Madam President, under the offense of narcotic offenses, we have 316 reported cases. We have in 2020 316 detection happening as it relates to narcotic offenses. So it means all of the cases as it relates to narcotic offenses, we had a detection, across the board detection. Madam President, in 2021, the statistics suggest that there were 314 reported cases of narcotic offenses. That's in 2021. And Madam President, in 2021, we have had 214 detected cases under this offense. So again, we are looking at 314 reported cases in 2021. They were able to solve these cases, 314 of them in 2021. Again, I want to respectfully reiterate to the members of this Honourable Senate, especially to those sitting on the independent bench, of whom support we are relying upon. We are not ideally where we want to be as a nation, of course, as it relates to crime fighting. But if we are to look at some of the statistics that has been presented to you, we can certainly see that some of the offenses, Madam President, that fall under Part 2 of the first schedule of the Bail Act, in which this extension will apply to, that we can say resoundingly that there has been significant impact of the application of this restriction in the TTPS having, of course, the time to be able to, at least solve the cases which have been reported to them. Madam President, I don't want to become too redundant. I know it's different statistics, but let me just look at one more based on the stats that I have here. Let's look at in robberies, for example. In robberies, Madam President, excuse me, in 2019, we had 3,018 cases reported under the offense of robbery. Detected cases were 521 cases. In 2020, we have 2,082 cases. Well, of course, the detection rate was 278. In 2021, we have 1,868 cases of robberies reported. We have 432 of those cases which were detected. So, and of course, there are several other offences here that falls under Part 2 of the first schedule of the Bail Act, which is 120 days will apply to. But this, Madam President, is respectfully to say to this country, imagine if the police did not have that additional 120 days to put their houses in order, to be able to accrue evidence, to be able to do whatever was required and necessary in order to actually be able to charge persons. Imagine if they were not given that 120 days. I respectfully, personally submit that we may not have even had the detection rate which we have here, that is presently before this Honourable Senate. Now, Madam President, as I'm coming out of the statistics, I want to use a very practical and a very practical, simple example as to why this 120 days is critical, I respectfully submit, in solving or assisting the police in crime, in being able to detect a criminal activity. Let's say, for example, Madam President, we have somebody who is,
Thank you for giving me. Would you have the solvency rates?
Do we have the
solvency rates?
I don't have that information before me. What I have before me, unfortunately, Senator, would be the detection rate and the reported cases. But hopefully I would be able to get that information. Madam President, so as I was saying, if I can take this Senate respectfully through a very simple exercise of that 120 days and the impact this could have had, I respectfully submit on the statistics that I've just presented. Let's say someone, for example, is charged. Let's say there is an offense of, rape or sexual penetration of a child. We have sexual penetration of a child, and let's say the minor is about 14 years old. We are looking at the sexual penetration of a child and the minor being 14 years old. Many, and this is not across the board, but I'm just using this as a hypothetical example. We have a 14-year-old child who, let's say her boyfriend, she's in a relationship, a bona fide relationship with a 20-year-old or a 25-year-old. This child is 14 years old. In most instances, what you will find is that the informant in this matter may be a parent of the child. And the child may not necessarily be too pleased that his or her relationship is being reported to the police, and more so the boyfriend is being reported to the police. Now, when you have this report taking place, Madam President, it's not that upon the report we all understand that the police can't just simply go and proffer a charge. What can this 120 days provide to the police? That 120 days with this person inside, with the accused inside, can allow the police the opportunity to be able to get statements from this child, who in this instance may very much not be willing to give a statement, because the scenario that I'm referring to is a case in which it's the boyfriend of the child, and the child may be reluctant to give the statement. So the police officer in this 120 days is given a window in which they can be able to at least attempt to solicit that statement from the child. In that 120 days, Madam President, we are looking, so the statement is one. In that 120 days, there will be medical evidence that the police would have to get in order to be able to prove penetration, in order to be able to prove that the offense did indeed take place. That 120 days, respectfully, Madam President, it gives the police the opportunity to be able to accrue that evidence. Any evidence that has to come back from forensic, it gives them the 120 days to accrue that. In that 120 days, Madam President, we have an accused in this matter. That accused in this matter, Madam President, may require counsel, whether it's a legal aid, whether it's a public defender, whether it's their own counsel, before giving a statement to the police. That 120 days, Madam President, affords the police the opportunity to be able to get that information. If we go further down the road, there are some offenses, Madam President, especially like, for example, in this sexual offense. If the police, of course, let's say the child is not willing to assist, the police may need, let's say, evidence of a cell phone. The police may need evidence from an internet service provider to show that there was contact between the accused, or let's say conversations that suggested that there was a sexual relationship between the child who's 14 years old and the accused, right? That 120 days, Madam President, it provides the police with the opportunity to accrue that evidence as well. All in all, Madam President, what I'm respectfully submitting to this Honourable Senate is that 120 days seems like a lot, but 120 days in essence, what it does is that it provides the police officers with the time in which, of course, not for a witch hunt to be conducted, but it provides the police officers with the opportunity in which they can accrue the necessary evidence that would warrant the commencement of a matter against or a charge being proffered against the accused. So, Madam President, in a nutshell, that is just a very simple example. Of course, there are more complex examples, and the more complex the matter becomes, as of course, the 120 days will simply not be enough for police officers to be able to properly accrue the kinds of evidence that is required for them to successfully detect an offense. But just respectfully submitting, Madam President, from a very simple place, that at 120 days, it is in essence going to support the police officers with the support that they would require, which could have possibly resulted in some of the statistics, Madam President, I would have presented as it relates to the detection of offences that, of course, falls under Part 2 of the first schedule of the Bail Act. Now, Madam President, that in a nutshell is really just my 2 pence in answering to the question that was raised both by Senator Mark as it relates to statistics, and because I know the Honourable Senator would have referred to this amendment as draconian. And my respectful submission is that if we look at the statistics that were presented, bearing in mind, yes, and I reiterate, we are not ideally where we want to be. The TTPS is not ideally where it wants to be in the detection of crime. I recognize that. But at the same time, Madam President, we have to recognize that we have been able to make, that the TTPS certainly has been able to make certain inroads as it relates to offences in which this 120-day bail restriction will apply to. Now, Madam President, can you tell me how much more time to full time?
You finish at 12:54. It's 12:41 right now.
Okay, thank you, Madam President. Now, Madam President, if I may now respectfully get into the crux of my presentation. Now, yes, the bill is a very small bill, but as I would have started off by indicating, it is by no measure a simple bill, because of course it stands to fundamentally impact on our criminal justice system. Now, I want to briefly begin, Madam President, by looking at some of the support that at least this bill, Madam President, we all recognize that we would be trampling upon constitutional rights of a citizen, all right? And hence we have the majority provision provided in the bill. That's why there's the majority provision required. So we all of that, the constitutionality of it, that entire discussion, we understand that. But what I believe was equally important to understand, Madam President, is perhaps what is the public's opinion, or what has been the support in the public domain as it relates to the extension of this bill. Now, Madam President, while we know, of course, if we look at the spirit of bail, this amendment before us, we understand, is short, as it is indeed, Madam President, as I would have stated before. It's a 3-clause bill, and of course, it requires us to address major constitutional rights of the accused. Especially, I know Senator Mark would have made reference to Section 5(2)(f)(3) 3 of the Constitution, that an individual has a right not to be deprived of reasonable bail without just cause. Madam President, I agree. We all know that 2 fundamental principles of the criminal justice system is that a person is presumed innocent until proven guilty according to the law. Madam President, we also know that a person should not be denied his or her liberty. So we understand all of that. But you know, Madam President, in preparation for this particular bill, it took me to an article, Bail Law, Developments, Debate and Statistics briefing paper of 2010 by Lenny Roth. And that stated, Madam President, when the Bail Act was enacted in New Wales in 1978, the then Attorney General, Honourable Frank Walker, stated that the laws attempt to strike the necessarily delicate balance between the right of an unconvicted accused to be at liberty, on the other hand, and the protection and welfare of the community on the other hand. So, Madam President, the question is, understanding the above, why are we here, Madam President, asking for the support of this Honourable Senate? Madam President, we are here asking this Honourable Chamber to extend the time period for a further year. And we are doing that because it is exactly in accordance with what the Honourable Frank Walker of New Wales stated. We are asking for this amendment, Madam President, already alluded to by the Attorney General, for the protection, Madam President, and for the welfare of our community. Let us not forget, Madam President, that we all have a responsibility, as we all know, to protect all of our citizens of Trinidad and Tobago. Madam President, in preparation for this particular bill, I would have also come across an article, Loop TT News article by the Reese Polo, and it was dated the 24th of June 2020. And it was an article in which the present Commissioner of Police made a statement. That statement, Madam President, is entitled, Police Commissioner Begs for Extension of Bail Act Set to Expire Soon. In that article, Madam President, according to the Acting Commissioner, the Bail Act has assisted in convicting persons accused of serious crimes and targets repeat offenders. I believe some of my colleagues already made mention to this article, so of course I would not want to get into that. But here we have the head of the TTPS currently recognizing that this particular extension can play a critical role in us going back to previous Attorney General of New South Wales Walker's position. It can certainly help us in protecting our community. I came across an article as well, Madam President, by the former Commissioner of Police, Mr. Gary Griffiths, and in that article, Madam President, even the former Commissioner of Police highlighted the need for persons who face multiple charges to be denied bail. And it was in a CNC article entitled, Griffith Makes Fresh Appeal for the Passage of Bill Amendment, written by Charlie Rampasad, dated the 4th of February 2021. And of course, Madam President, in this article goes on again to explain, as a Commissioner of Police, Mr. Griffith recognizing the role that this extension in the bail amendment could have played in the TTPS being able to execute its responsibilities in managing criminality in our country. Now, Madam President, we also had an article by the Minister of National Security. It's another article that I came across is the Guardian article dated June the 24th, 2022 by Charlene Rampasad, entitled Bail Act Set to Expire, Government Lobbies Citizens for Its Extension. Now, in this particular article, Madam President, the Honourable Minister of National Security stated the legislation is very important in the fight and the response to criminals and criminality, in the protection of the citizens of Trinidad and Tobago, which of course, not just as a Minister of Government, but as a citizen of Trinidad, I completely endorse. These were just some of the support that I have seen in the public domain as it relates to this particular extension. Now, Madam President, in the few minutes that I have, if I may now respectfully turn to clause 3 of the bill, which is the crux of the bill, which seeks to amend section 7 by deleting the words 3 years and substituting the words 4 years. Now, I know Senator Richards would have spoken about what a sunset clause is. And Madam President, if I may respectfully add a little bit to that position advanced by the Honourable Senator. Now, in the 2016, Madam President, Law Journal article entitled Snoozing Democracy, Sunset Clauses, De-Justification and Emergencies by Antonius, it was stated that the adoption of a sunset clause simply postpones decision regarding extraordinary powers. Therefore, sunset clauses might not always be a shield against the normalization of extraordinary emergency provisions. Accordingly, Madam President, this sunset clause in clause 3 of the bill, I want to reiterate, is a temporary measure contingent on a new legislative decision. Rather than making a permanent amendment, Madam President, to the statute books, which may have more far-reaching consequences, Madam President, owing to a change of circumstances and in the near future, what we are doing is making a temporary change to the legislation. Now, Madam President, I want to respectfully submit again and ask this Honourable Senate, in the government recognizing that we are standing upon certain constitutional rights of the accused. Why are we still here asking for your support?
Minister, you have 5 more minutes.
Thank you, Madam President. Why are we still here requesting the support of this Honourable Senate? Why are we still here requesting the support of the country? Madam President, I want to briefly look at the concept of reasonable bail. Madam President, Wooding CJ, in the case of Collymore versus the Attorney General, made the point with his usual precision that in the Bills of Rights of our Constitution of Trinidad and Tobago, specifically Section 4 of the Constitution, that no right is absolute. In other words, Madam President, you cannot have a situation in which any one individual can enjoy a right absolutely, simply because the concept of absolute rights lead, as we all know, to anarchy. Therefore, Madam President, such rights have to be subject to limitations in order to justify a reasonable incursion. And what we are attempting to do today, Madam President, is to justify to you, the members of the Senate, why we are attempting to make this reasonable incursion on the rights of our citizens. Now, Madam President, to that end, if I may respectfully look at, very briefly, a statement that was made when this Parent Act, Madam President, the Bail Act, Chapter 560, was passed in the Parliament. And the then Attorney General, Keith Sobian, made a very profound statement, which would perhaps be the last thing that I contribute in this debate. Hansard dated, Madam President, August, and this is what I respectfully want to remind the members of this Honourable Senate of what I believe was a profound statement made by the then Attorney General. Hansard of the House of Representatives debate held on August 12, 1994, page 13. The then Attorney General, Keith Sobian, in his piloting of the Bail Act, Chapter 460, stated, the Bill of 1994 therefore provides that repeat offenders forfeit their right in the same way as the one-time offender in the existing circumstances, murder and treason. The society must express its abhorrence of heinous crimes, and we have to find a mechanism for balancing the rights of the individual to liberty and the right of the community and the citizens to security. To live with within their homes and to conduct their normal activity. Those are the rights that we are seeking to balance. And this was a statement made by the then Attorney General, Keith Sobian, in 1994 when this bill was piloted. Madam President, bearing that in mind, I want to respectfully ask the members of this Honourable Senate to consider giving the government the support that we request today. This amendment, Madam President, I believe when we look at what can be achieved and obtained, certainly that outweighs the concept of this amendment being draconian. So to this end, Madam President, I stand in support of the Honourable Attorney General, and we do ask for your support. Thank you, Madam President.
Senator John.
Very much, Madam President. Thanks for the opportunity. Madam President, here we go again, because the government comes to the Parliament to amend already draconian laws